What's going on, everybody? This is Lady Luck. All right, welcome back. Welcome back. I have another great video lined up that I wanted to do. I actually had a day off today, so I wanted to get a couple of pre-recorded videos in before I go live this evening, which I want to be able to do and just kind of let loose and have fun. But we're going to take care of some business in this video today. We're going to be talking about the lawsuit from the Dolton firefighters. And there's a case that I came across while trying to still research and find this collective bargaining agreement that was signed by newly elected Jason House, along with Adam Farage of the fire department in Dolton. I know in the previous video I went over just kind of some of the information from their lawsuits and then showed the photo that was on Facebook for the Dolton firefighters page of Jason House signing the new agreement with the firefighters that was well deserved. You know, the firefighters are part of a union, just like the police officers there, and most fire and police departments are part of a union, and want to make sure that they have those collective bargaining agreements in place that ensures that they are, provided the proper salaries and benefits, and that the local government entity that they're serving, make sure that they treat them right. Give them uh, the benefits and the pay, and ensure that they are not undercut, basically, and they have the respect that they deserve. So we're going to go over again the lawsuits. These lawsuits also include David Duval, who was the time I think he might still be the union president, but I know he was at one point. So David Duval has um is listed as a co-plaintiff in the lawsuit. He stated that he was retaliated against by Super Stupid because he wouldn't kiss the ring. Basically, he wouldn't kiss her ass, and she retaliated, and you know the entire the Dalton firefighters department had to suffer because of her nonsense, simply because she's a petulant child and threw a tantrum. But the way they were treated was wrong. They showed up to a town hall meeting as a show of force, and they voiced their concerns. They even indicated that there was, potential wage theft going on, where wages was taken out of, their check was being deducted for insurance premiums, but wasn't making its way to the actual insurance company. And they were finding out the hard way when they were forced to pay out on claims, and when those claims couldn't be paid out of pocket, they ended up suffering with, having these things reported to the credit bureau and collections, and affecting the credits. So you're talking about this ripple effect of just damage that Super Stupid has done, that the dumbass goons still don't want to read about, while they sit here and fuss at fire hydrants. Funny how that happens. But never mind the fact that some of these firefighters are now in collection status and having to have their credit repaired because they thought they had insurance coverage on a claim that was that had premiums being deducted out of their paycheck that did not go to their policies, that was not being paid on their behalf from the village of Dolton, all because of one miscreant from hell. So we're gonna touch on that in these lawsuits because, unlike the goons, that is her fault. They want you to believe that it's not, but it is. That is all her fault. Who has the power to override a mayor and say some payments should not go to the insurance company? She can't even blame that on Freeman. As much as I hate him, I don't hate him. I just really despise him, and I hope he goes to prison. But that's my 2 cents. But these are the things she did out of retaliation because they wouldn't support her campaign. It was not Keith Freeman's campaign. It was Super Stupid's campaign. And because of that, they experienced the retaliation. So, and that's what it comes down to. And that's what's in the court documents. And I'm sure the judge is well aware of it. So, whether the goons believe it or not is irrelevant, just as much as their presence here on earth is irrelevant. It's irrelevant. It's all about what goes on in the court. And in these lawsuits, there are real people hurting here. And you have morons trying to dodge and deflect accountability from her. And it's just appalling. It's egregious. All right, so let's get started. We're going to take a look at the amended complaint. And as you all can see here, this is the first amended complaint. There were a couple. I have a response, I think. Plaintiff's response. So, of course, the defendant, being the Village of Dolton, had filed a motion to dismiss, like a partial motion to dismiss the first amended complaint, which is what we're looking at. So I'm going to kind of go over that as well. And then I'm going to go over the administrative hearing that was conducted by the Illinois Labor Relations Board and what their recommendation and order was. And there's a separate case that I want to touch on, Gordy Taylor v. Village of Dolton, which is, it was a big shocking to me to come across this, but I thought it would be, interesting to share. Sometimes we want to forget certain things depending on who it is, but this is how complacency can land you in a place where you're still fighting to get rid of, corrupt politicians, or you're, now protesting again for some form of justice, because depending on who it is, people don't want to say anything. This is not about a matter of dying something down or calming. It's not about that. It's about making sure that you stay vigilant and that you hold people accountable, because they're grown. We're not talking about children here. So let's not pacify them as if they're children. They're adults. Whoever may be in that position as the mayor in the Village of Dolton, he should be held accountable, because it's just the right thing to do. I don't go around bashing Jason House. And I think I've only fussed about one main thing, and that was about he who will not be named being put on a committee. And they undid it. Thank God. They corrected that. They realized there's too many people fussing at us, and Lady Luck Club is going to keep making videos. So something had to be done. The residents didn't like it. But if you all get quiet, you sit here, give a chance. You said the same thing with Super Stupid when she first came into the position. And look what happened. Stop repeating the past. It's not working. Don't repeat your past mistakes. Don't get complacent. Just stay vigilant. Make sure you do your due diligence. And keep your eyes open. You don't have to bash anybody 24/7. I don't believe in it. I think it's very extreme. Some of these goons are extremists to just sit and bash 24/7 while they ignore the buffoonery and the unlawful conduct of Super Stupid. It's completely one-sided. But when there is a matter that needs to be resolved, when people take you seriously, it's because you're truly concerned and you're coming from both angles here. You're able to say, this is the stuff she did wrong. Here's what he's done wrong so far. Let's make sure they are both being held accountable accordingly, and that the right amount of pressure is being applied. That does not mean that you have to stop voicing your concerns, because if you do that, then all of what you've done for the last 3-4 years of trying to get rid of Super Stupid will become a moot point, because now you're just repeating the cycle. Don't do it. I told you all, Georgia, we handled Rafiki down here. Mayor Rafiki regrets being a mayor because his check is being garnished. And understand, a garnishment can still occur even if you get another job. So a Super Super get another job, just because she's not the mayor or supervisor anymore does not mean that a court cannot order her check to be garnished. You just simply need to know where the hell she's working. That's how that works. because a court order would override where she works. I mean, seriously. Let's not, there's just certain things that can be Googled. If if you're not aware, I'm telling you now. But always challenge me and fact check me. You can get a court order to get someone's wages garnished. Doesn't matter where they work. You just need to know where they're working. So that solves that problem. That riddle is solved. So if a court was to order her to have her check garnished as a form of judgment against her, okay, well, who's her employer? That's all they would need to know. And they would sign the order to have, an income deduction done against her wages. That's it. It's that simple. And then if they can't get it all out the wages, okay, well, make sure that her tax refund checks are withheld too. They'll go as deep as they need to go. Boom, shakalaka. Moving on. Let's get to this. All right. Because I'm fussed long enough. This is in the Dolton Professional Firefighters Association, Local 3766 IAFF, and David Duval versus Village of Dolton. Super Stupid in her official capacity, and the village administrator Keith Freeman in his official capacity. Case number 2023, C as in cat, H as in hat, 00660, first amended complaint. So you have the plaintiffs, as stated, bringing forth the complaint against the defendants as listed. And you guys can see there, David Duval being a co-plaintiff with the Dolton Firefighters Association, and the nature of the action being as such, this lawsuit arises under the Illinois Wage Payment and Collection Act, 820 ILCS 115/1, etc., and the Whistleblower Act, 740 ILCS 174/1, etc., for defendants' conduct of 1, failing to honor the voluntary 457 retirement plan agreements and timely deduct money from the wages of village employees and plaintiffs' members, Lance Bergeron, Jeremy Cole, Ian Cosgrove, Anton Downing, David Duval, Adam Farage, and John Smith, which are referred to as affected employees throughout the rest of the complaint, and ensure that those deductions were, are, and continue to be provided to the vendor in a manner that enables timely deposits into the appropriate accounts, and 2, threatening Duval with retaliation for disclosing info to a government agency where he had reasonable cause to believe that the information disclosed a violation of state law. So that would be the Whistleblower, Protection Act at its finest. That's pretty much what that is. All right, and then they have some exhibits. Exhibit A, you guys can see there. And that exhibit is going to show, it should show the actual wages, deductions, and what it was supposed to be going towards, which will be interesting to see. So, like I said, I've kind of skimmed over this in the previous video, but didn't dive into it like I really wanted to. So that's what we're going to be doing. Pursuant to the IWPCA, and this is 820 ILCS 115/3, 4 and 11 sub D. Count 1 of this action is brought by the plaintiff union for defendant's failure to honor the voluntary plan agreements entered into between the village and the affected employees and ensure that the village honors its past, present, and future obligations under the plan. So now you all understand why Adam was speaking on a possible wage theft allegation, because you're taking money out of somebody's check. You agreed that it would go to a specific vendor to cover insurance plans as a premium, but then it didn't go there. So where did it go? You still took it out of their check. Where did that money go? So, yeah, I'm wondering if that riddle has been found out. And if not, that might be why the case is still open. Still trying to figure out where that money went. Pursuant to the Whistleblower Act, 740 ILCS. And then you guys can see the subsections here, 174/5, 20.2, 25, and 30. Count 2 of this action is brought by the plaintiff Duval for defendant's conduct And this is what Duval specifically is bringing forth regarding this count under the Whistleblower Act being violated. So the defendant's conduct of threatening retaliation against Duval, an employee of the village and president of the union, for his disclosure of information to a government agency about the village's failure to timely deposit and or failure to ensure timely deposit of affected employees' plan monies or contributions, which Duval reasonably believed to be a violation of state law, which is reasonable. I mean, it wasn't making its way to the insurance companies, and the insurance company was like, well, you guys don't have a plan anymore because premiums weren't paid. That's a horrible way to find out that your insurance no longer is applicable because you're getting this money taken out of your check, but your employer somehow is just allowing that money to disappear into the cosmos. Maybe the goons will kind of help find out where that money went if they be so bold to do so and they have a spine. I highly doubt it. All right, moving on. Parties. Village of Dolton is a municipal corporation. Um, the Village of Dolton is located in Cook County, pursuant to sections 5-3.1 15 5 and 5-3.1 15 10 of the Illinois Municipal Code 65 ILCS. And then it repeats the statutes again. Defendant was elected to serve as mayor in the Village of Dolton in February 2021. At the time that this was filed, she was still serving in that capacity. And then, of course, they note that Freeman was appointed to serve as the village administrator. Serves in the capacity. Well, at the time that this was filed, he was serving in the capacity. His duties included participating in contract negotiations and addressing day-to-day matters and issues with plaintiffs, which he didn't do because he was a lapdog for Super. Pursuant to Section 11-6-1 of the Illinois Municipal Code, 65 ILCS 5/11-6-1, the village has maintained a fire department of full-time paid employees. Plaintiff is a labor organization with the meaning of Section 3I of the Illinois Public Labor Relations Act that represents firefighters in which public employees participate. Plaintiff exists for the purpose of dealing with the village concerning that should be concerning wages, hours, and other terms and conditions of employment concerning bargaining unit employees. There you go, concerning. What happened to the spell check here? I got it. All right. Duval holds the office of union president, and Jeremy Cole, individually referred to as Cole, holds the office of union vice president. Affected employees are employed by the village's firefighters and are members of plaintiff union. This court has jurisdiction over this matter, and that is pursuant to Illinois Wage Payment and Collection Act and the Whistleblower Act. And then the statute codes are cited there. Venue is proper in this court, according to the Illinois Code of Civil Procedure. You see the statute cited as well. Plaintiff and village are parties to a collective bargaining agreement. A collective bargaining agreement. Effective May 1, 2017 through April 30, 2020. So at the time this was filed, in 2023, their bargaining agreement had expired in 2020. So they're going into what? Year 3 with no bargaining agreement. It covers all village fire department employees holding, sorry, I'm taking a sip of water, holding the rank of firefighter, engineer, shift lieutenant, and shift captain. Copy of the CBA is attached here to as Exhibit A. Oh, nice. At all relevant times, plaintiff union and village have been engaged in negotiations for a successor collective bargaining agreement. So they basically are saying, we've been in talks with trying to get a new collective bargaining agreement. We don't have one. It's been 3 years. How long does it take? So a lot of times once it's established, you may have some changes here and there depending on pay increases or change to, insurance companies or those sort of things. But it shouldn't take 3 years to make sure that the new CBA is amended or updated to address any changes or demands, from the union to the local entity that they serve, whether it be a village or city or whatever. So It's crazy how it took this. It took all that time. They just got something signed last year. 4 years. Took 4 years. All right. So, pursuant to Article 20, CBA remains in full force and effect. Was it expired or not? It says effective May 1, 2017 through April 30, 2020. Okay, so it must be indicating based on that article that the whatever the most recent one is effective until a new one replaces it. That's my understanding of it. Yeah, I didn't look at the article. So I'm not a lawyer. I didn't go to law school. I'm just reading the information. Oh man. All right. The CBA establishes the negotiated terms and conditions of employment between the village and union. Village employees have the option of voluntarily participating in the plan, through which they authorize the village to deduct money from their wages on a tax-free basis for deposit into a retirement account. This is tax-free money, y'all. The plan is currently offered through Nationwide, right? The plan was not negotiated between the union and village. It is a voluntary plan that exists outside of the CBA. Pursuant to the plan, the village deducts amounts specified by the affected employees from their wages each paycheck issued bi-weekly, and is supposed to take appropriate measures to ensure that the monies or contributions are deposited into their plan account. Got it. Affected employees voluntarily participate in the plan and have authorized the village to deduct the specified amounts of their wages from each paycheck for the sole and specific purpose of having those monies or contributions deposited into their plan accounts. So there should have been separate expense accounts for those plans that the village of Dolton was taking out of their check. And it should have gone straight into the plan accounts, which still would be indicated like with an account number or some sort of expense account that is specifically to be used to go to Nationwide. Where is that money? What happened with those accounts? Yeah, these are the questions that we still ask. We were outraged when the firefighters came to that town hall meeting, were we not? And they brought up these concerns, and now people want to pretend like this doesn't exist. This is still going on in court. You don't have to be angry, but you should be pissed because you the goal is to still follow the money. Where are those accounts? What happened with the money? It's that simple. In July 2022, plaintiffs learned that although the monies were deducted from the affected employees' paychecks, all deposits had not been made and or were not being made in a timely manner. Where is the money? Show me the money. Plaintiffs through Duval emailed village officials and addressed the village's failure to make the required deposits. There's only one time I want to tell you, make sure this money goes into an account according to whatever agreement we have, or I'm suing the shit out of you. That's it. That's not even something I'm asking you to do. That's a heads up. Where's their money? That's their money they earned, and they wanted to go into this specific account. And you mean to tell me that it didn't go to Nationwide? Come on now. And no one's trying to solve the riddle. Because now we want to be quiet. Because Jason House is now the mayor. Where's the money, Jason? Not saying you took it, but can you help them find it? That's it. It's that simple. See? Accountability. All right. A copy of the July 2022 email chain is attached here too as Exhibit B. Subsequently, the village made some, but not all, of the requisite deposits. In December 2022, plaintiffs through Duval again addressed the village continued conduct of making the plan deductions from the affected employees' wages and failing to make the required deposits into their plan accounts. Copies of non-exhaustive examples of the earnings statements, plan deposit statements, and account histories are attached hereto as Group Exhibit C 1 through 8. My goodness, non-exhaustive. It's quite descriptive. On December 30th, 22, plaintiffs through Duval emailed Janice Johnson, individually referred to as Johnson, village director of administration, Cristiano Mirobali, Am I saying that right? A village accountant, and super stupid regarding the village's continued failure to make the required plan contributions. So when they got to that town hall meeting as a show of force, remember that happened? The firefighters showed up at the town hall meeting as a show of force. And then she sat there looking like, a chicken with her head cut off, eyes buck wide open, and then lied through her teeth talking about she did not know what they were talking about. Never mind all the emails that could document not them just sending the email, but her receipt of such. It's called a read receipt. A read receipt. When you're dealing with Ewoks like her, you don't just email someone like her and then let it be. No. No. You need a read receipt. I want confirmation you just clicked on the email itself. You gotta check all the boxes with somebody like her incompetent ass. All right. So the village's continued failure to make the required plan contributions. A copy of the December 30, 2022 email is attached. Copied to Trustee House, Trustee Belcher, and several union officers on that email. Duval received no response. So what happened with House, Belcher, and the other union officers getting the email and responding? Nobody responded? Okay, let's just keep reading. Because I mean, this you got copied on it. I would be like, oh, we got the email and we're gonna make sure we handle this. And we resolve the matter. Yep. No one's scared of super stupid. We're gonna get this done because we need our firefighters to be okay. We need them to be taken care of. They fight fires. They do a lot of things. You can call 911 for an emergency and request for a paramedic, and the firefighters might show up first. So don't underestimate firefighters and the role they play. Plus, they use the jaws of life, and everybody needs that once in a while. So let's make sure our firefighters are happy now. January 11, 23, plaintiffs through Duval emailed again. So let's backtrack. They got another email on January 11, 23 through Duval. Emailed the same individuals about the same issue and stated that the village's conduct could be considered wage theft. Copy of that email on January 11, 23 is attached here to as Exhibit E. So my whole question is, despite super stupid not wanting to respond because she can't read, why is it that House and Belcher and other union officers did not respond? And I get it that Freeman, being the evil entity he was acting like, was trying to prohibit people from actually doing their job, which is why in my mind, between that and him actually being indicted, that doesn't give him a pass. No, you don't. You don't get a pass. You're doing what you're supposed to be doing. It just took an indictment to get you to do something right. You don't get a pass for that. But he blocked a lot of them from being able to give out information. They tried to control everything because look at what you have now. You have what's considered to be wage theft, and money is still missing. Where is the money? Where are those accounts? What's going on with it? Like, that can't be eradicated. That money is still out there in the cosmos. Where is it? So you're talking about money that will have to be repaid back to the employees. We don't care that super stupid like to misappropriate funds and had Freeman doing her, bidding and trying to keep everything under wraps. So what? You still owe us our money back. The end. So how is this going to happen? That's what it comes down to. They're going to have to get reimbursed for that because that is a violation of federal law. Oh my God. They didn't care about breaking laws at all. She broke many laws that's in many court documents. And you got idiots sitting here trying to defend it. Jesus. All right, moving on. During the afternoon of January 11, 23, Fire Chief Peter McCain, individually referred to as McCain, and Freeman called Duval on the phone, questioned him as to why he sent that email on January 11, accused him of sending the email because of the upcoming election. Like anyone gives a damn about an election. Where is the money at? Where are those accounts? The simplest, just the most stupidest stuff ever. It's so simpleton minded. This is why I said Freeman is not redeemable in my mind. You'll be redeemed when you go to prison. That has got to be the most simple nonsense ever. Oh, you doing this because of the election? Nobody care about her damn election. Where's our money? Are you kidding me? Oh man. So of course he would insist that Duval should have contacted him directly, like anyone owes him that call directly when you ignored the email the first time, Freeman. And continued to insist that Duval included the trustees in the email because of the upcoming election. They were all included. And you want to sit here and have control. With great dumb power comes great responsibility that you can't handle. The end. Jesus. Freeman berated and swore at Duval during January 11, 23 phone call. Freeman ended the phone call by telling Duval that he wanted Duval to meet him at Village Hall the next morning. Please. First of all, I would have been like, who the hell are you talking to? And I'm going to live stream this call. Post that call up. See, y'all got to learn how to record stuff. Duval should have recorded this phone call. He should have live streamed it. Oh, you want me to meet you somewhere? Oh, okay. All of the internet will be coming with me. Got it here. So on January 12, 23, Duval and Cole attended a meeting with Freeman, McCain, Johnson, Tangerine Miller, village finance director. Duval again explained the problem and explained why he sent the emails. The village employees were hostile from the outset of the meeting and repeatedly questioned Duval as to why he accused them of theft. How many times does he have to answer that? It's called theft when the money is missing. Did you physically take it out and put it in your pocket? Maybe not, but who knows? No one owes you that leverage of assuming you didn't steal it either. Because where is the money now? Perhaps you can just pull out the accounts and show me where this money is that came out of my check. Where did it go? What are the account numbers to where this money was deposited into before it goes to Nationwide? There we go. Is it with those Fifth Third bank accounts that Super Stupid had the village clerk unlawfully removed from? That's also in court documents. Violating many state laws and local ordinances to do that dumb shit, where she added Keith Freeman, Tanjanique Miller, and Janice Johnson to those accounts without board approval against state law. Did the money go to that account? Because I'm starting to think that. I'm starting to think that the account that Super Stupid had the village clerk removed from with regards to the Fifth Third bank account was that account where that money was going to from the firefighters' checks. Because Tanjanique Miller, Janice Johnson, and Keith Freeman had access to that account unlawfully until the trustees had to take her dumb ass to court. And then that's when Jason House was listed as a signatory, and she agreed. Her and her counsel, with the defendants being the trustees and their counsel, made an agreement with the court that Jason House would remain as signatory on that Fifth Third bank account with the village clerk, while she still lied that she was booted off and talked about how she had absolute power to do nothing that she did that was lawfully correct at all. This is what happens when you listening to voices in your head when you're already dumb. And then you get idiots around you, egging you on, having you think that you actually have absolute power because they're just as ignorant as she is. This is the crap that happens. Look at how it affects so many other people negatively. And yet they want to sit here and say she's not going to prison, even though the FBI is investigating her dumbass. No, she's going to prison. She's going to prison. It's funny how the people saying she's not are not lawyers. They didn't go to law school. They can't tell you a law to save their lives. It shouldn't even be something too difficult to figure out. Because see, these cases like this, get used as a part of the FBI investigation. They laid a foundation to establish her lawlessness and just her ability to perpetuate issues that stem from her believing that she had absolute power and that somehow she's above the rule of law. This is the insanity that comes out of it. And this is what people want to get quiet on now? Really? Jason House won. But if he didn't do anything wrong, there's nothing horrible about being concerned about what's going on with the courts with these lawsuits. Because guess what? If there's a judgment issued against the village of Dolton, and these firefighters now get a judgment granted in their favor, that money is going to come out of the village of Dolton. So you should still be concerned. Otherwise, it just makes no sense. There's no logic to that. Don't say anything about anything because you don't want to be seen as negative. But man, when that judgment hits, now all these lawsuits is costing us money. Yes, it is. Yes, it is. Which is why you should stay involved throughout the process. In all that getting, get some understanding, and in everything you do, use wisdom. That's why you can't just take your hands off the stuff because Jason House won. It's not directly affecting, like, he's not the bad guy in this. But it begs the question, why would Super Stupid go out of her way to break laws, which is a crime, to have someone unlawfully removed from a bank account, unlawfully use her signature stamp, which is a violation of federal law? That's a felony, by the way. That's identity theft. That's a felony. And then filling out bank documents, that's bank fraud. Those are felonies. What are you talking about? Those are considered a part of white collar crimes, which they're investigating, along with kickbacks and everything else. Why would she go out of her way to remove the village clerk from that bank account? And just so happen to add these same people listed here in this lawsuit here: Freeman, Janice Johnson, and Tangenique Miller, against state law, local ordinances, and without the approval of the trustee board. And it's mighty ironic how those same accounts that were supposed to be holding the wages of the firefighters were being put into these accounts. It's being taken out of their check, being put in these accounts, but it never made its way over to Nationwide. Those deposits did not make its way over to Nationwide. So they went from one account to another account, and then once it got there, where did it go? Following the money does involve sometimes having to bring up real issues to people that you might not like. But it is what it is. The FBI will follow the money. They don't give a damn who it implicates. They're going to follow the money. That's it. So, moving on. Duval again explained the problem for the umpteenth time and explained why he sent the emails. The village employees were hostile from the outset. They repeatedly questioned Duval as to why he accused them of theft and characterized his emails as hostile. No, they were just truthful. You know, with Duval, I wish I would have been able to just kind of get, coach him on some responses here. I would have said, so why is it you all are going behind the board of trustees back and removing the village clerk off of a bank account again? And these same two people sitting in this room, three of you all sitting in this room were unlawfully added to that bank account. Show me a statute to where you had the right to be added to this bank account against the actual ordinance that was passed. Where is it at? That's all he would have had to say. Would have shut him up. Oh, man, they're going to be in so much trouble. Duval maintained the position that he was trying to resolve the problem, had not received a response from the village because he didn't, and that the problem remained unresolved. As Duval tried to explain the problem and why he sent the emails, Freeman cut him off. Freeman is the worst, and kept bringing up the alleged accusation of theft. It's missing. Call it what you want. Look, define the term theft. But you know what? We're going to do that right now. Because I believe it's this definition of terms that seems to be thwarting a lot of people when it comes to things. People are getting confused at things because they don't know the definition of these terms. What the hell is the deal? Is it too hard to just look up the definition of the word theft, Keith Freeman? You can't be that stupid. Or maybe you can. I just whatever. Jesus Christ. Ah, theft. I'm baffled as to why he kept harping on that. As if he could explain where the money went. Where did the money go? We're still waiting on those accounts. Where did the money go? Oh my God. All right, because we had to take a break and define words. What is theft? Theft is a term used to describe a crime that involves taking a person's property without his consent. In the law, the term theft encompasses more than one act, but in order for an action to be considered theft, two key elements must be met. These include taking property from its rightful owner and having the intent to deprive the rightful owner of the property permanently. So, whether you put your hands on some money and put that money in your pocket, Keith Freeman, Janice Johnson, and Tangier Miller, and to the dumbass goons who don't read, is irrelevant to the definition of the word theft, as you can see. The fact that the money that belonged to the rightful owners, being the employees, left their checks, went to an account where an agreement dictated where it should go thereafter, which would have been to Nationwide, did not make it there. So you took money from the rightful owners. You agreed that it would go into an account. And somehow it didn't go where you agreed in a contract that it should go. So it still belongs to the rightful owners, being the employees. Where is their money? Theft of wages, as defined by the law, involves these two key elements. Where is the money? He does have the right to say this is wage theft. It's that simple. This is what happens when reading becomes fundamental. Because, we had to do this breakdown of one word. When we was going over Keith Chicken Nuggets video. Because, no one, I guess he just didn't understand the concept of false or the definition of that word. So we looked it up. So now we have to look up theft here. Because, Keith Freeman getting paid all that money, $90,000 of it he owes back to the Village of Robbins. When the hell are you going to do that? Because that's theft too. That's theft. That was theft. You took money from them in the form of wages, whatever, that you were not entitled to. You're not the rightful owner of that $90,000, Keith Freeman. So the Village of Robbins is wanting you to return their property back to them in the sum of $90,000. Give them their money back, you dumbass goon. All because he doesn't understand the definition of the word theft. You all see how much easier these things are to read and understand when simple terms and definitions of such are applied. Oh, Lord. Super Stupid kept some real morons and goons around her. I can't say any of these people were smart when they refused to look up definitions of simple words like theft, wages, vote, election. I mean, it's ridiculous because she tried to be the smartest person in the room. So Keith Freeman, understand that in her world, in her mind, you were dumber than her because her ego would not allow you to be smarter than that. Good grief. Taking a person's property involves taking possession or control of property that rightfully belongs to someone else. However, attempting to take someone else's property can also be considered theft. Did y'all hear this? No, check my microphone. Make sure it's high and loud. Attempting to take someone else's property can also be considered theft. This is where we are right now, Keith Freeman. Keith Freeman, because you kept asking, how can you accuse me of theft? Whether it be you or everybody else, he sent you an email, you didn't respond. And let's not forget the fact that you have actually committed theft by taking money from the village of Robbins. You owe them money. So it wouldn't just, I wouldn't be shocked if you were accused of it again and again and again and again. And you're listed throughout what, 3-4 FBI subpoenas? You're the worst. What the hell? Oh man, these clowns. If the perpetrator's intent was to deprive the individual of his property. So did you all try to get them their money back? You know, those email attempts where you all did not respond did not show that you were actually trying to avoid from depriving them of their actual property, being their money, that money you took out of their wages. That's their property. The element of intent is often the most challenging legal question in theft cases, as defendants often claim that they thought the property was theirs to begin with, or that they were just borrowing the property. See, in this situation, you can't say that you thought it was yours or that you were borrowing it, because the village of Dolton was not there to even hold that property in their possession. They were there to be a median to which the property went from the employees to Nationwide. That's it. That was the whole role in that transaction. Nothing more than that. You were just a middle person, ensuring that the money taken out of their wages, their property, went from their account to an account with the village of Dolton to an account at Nationwide. The end. That's it. It shouldn't have mattered how much, whose checks is coming out of, who's the union president. All of that shit is irrelevant. The village of Dolton's role was simply to ensure that that property, the employees' wages, went to Nationwide. And they couldn't do that. And when they emailed Keith Freeman and all these other clowns about it, and two trustees that just won again, nobody responds. Why? I'm not dogging them out. I am dogging them. I'm dogging out Keith Freeman and Janice Johnson and Tangier Miller. Because you guys have done some awful things, including completing bank documents to get a village clerk removed against the law, which was illegal. That's a crime. It's also bank fraud. So, I mean, you know, it's hard to believe some dumbass liars that don't know the definition of the word theft. So, of course, you have theft pertains to taking the property of another with the intent to deprive the owner of the property. There are several types of theft that may be charged, including robbery, embezzlement, burglary, identity theft, intellectual property theft. You know that identity theft thing, super stupid, where you were using the village clerk's signature stamp? Yeah, that's identity theft. Forgery as well. Forgery. Oh, man, that's a good one. Forgery. It's also forgery. You used her signature stamp that is treated the same as her handwritten signature here to sign checks. Check fraud, forgery, bank fraud. I can keep going. It's a whole lot in it. Theft can also be broken down into two major categories: petty theft and grand theft, which depends on the value of the property stolen. So depending on the dollar amount, it could be petty theft or grand theft. That can change the charge itself from a misdemeanor to a felony, but I could guarantee you this will be seen as a felony, especially if the FBI decides to bring forth charges of theft, of the wage theft, against these individuals listed as defendants. They're not going to bring forth a misdemeanor. Nah, they're going to come with a felony, a whole ass felony. And of course, you know, depending on how long this occurred, can also, you know, of course, naturally cause the amount to go up, because you got to understand insurance premiums do go up every year or every 6 months, however. So that's more money coming out of several different employees' accounts. We're not talking about like something less than $500 here. We're talking about thousands of dollars over what, 3 or 4 year span? Over a 3 or 4 year time frame. And then let's not forget the damages because of that. where firefighters had to pay claims out of their pocket. And when they couldn't, they went to collections. So now you're talking about the damage to their credit. And you got idiots sitting here talking about super stupid is not going to prison. Kick rocks, you incompetent imbeciles. If you really think that, look at the damage being done. Jesus Christ, all because they don't know the definition of the word theft. All right, now that we've got that accomplished, let's get back to it. Now that we all know the definition of the word theft, so that Keith Freeman can now, when he sees this video, because he will kiss my ass, you'll know what theft means and stop answering that. You can finally have that question answered. Why you keep accusing me of theft, Lady Luck? Because that's what it's defined to be. Jesus Christ of Nazareth. I can imagine this conversation getting really dumb after this. Because, simple things. And being cut off, oh, that is the worst. That is so rude. So Freeman cut him off, kept bringing up the alleged accusation of theft, which he was doing. Duval also explained that he copied Trustee Belcher because she oversees the fire department, and Trustee House because he oversees the village finances. During this meeting, Freeman raised his voice, swore at Duval, told him that he was wrong to accuse him of theft. No, he wasn't. You still owe the village of Robbins, you thief. And again accused Duval of sending the email because of the upcoming election. Don't nobody give a damn about her dumbass election that she lost. Freeman ended the meeting and told McCain to follow up with what they talked about, which was what? Duval asked if they were threatening him, as Duval understood that statement to mean that they intended to discipline him because of the alleged accusation of theft, when it could be proven in a court of law. That's funny. Freeman told them to leave the office and asked village police officer Terry Young, who was outside of Freeman's office, to escort Duval and Cole out of Village Hall. Oh, a hall that's meant for the public. You're having them removed unlawfully. They weren't criminally trespassed. You don't have the authority just to do that. Simply because you're mad. You told them to come there and then you want them to be removed? That's stupid. That could have been a Zoom hearing. That could have been a phone call. I'm not coming down there for you to try to have me removed. He did that to try to humiliate and shame them. This is how depraved Keith Freeman is. And disgusting you are. And I hope that there's a superseding indictment that drops upon your head and you go to prison. The depravity of this man knows no limit at all. None. Along with super stupid. They're like two peas in a pod. Good grief. During the evening of January 12, 23, Duval emailed McCain and informed him that he was not mentally prepared to work his duty shift the following day because he felt attacked and threatened with retaliation by Freeman as a result of the fact that he raised the plan. Issue. A copy of the email chain between Duval and McCain is attached here to Exhibit F. January 17, 23, Duval was placed on administrative leave and was under investigation for sending inappropriate emails to village officials because the village officials did not understand the definition of the word theft. Jesus Christ. A copy of the administrative leave notice is attached here to as Exhibit G. Let's see. Subsequently, on February 13, 23, only after the union filed an unfair labor practice charge with the Illinois Labor Relations Board, Duval was released from paid administrative leave. So they get bold and do illegal shit until they get told on, and then someone more powerful than them has to intercede. Yeah, all right. So it took a complaint to the Illinois Labor Relations Board in order for Duval to be released from paid administrative leave. You still paid him. Man, listen. You want to pay me to be at home? Oh, okay. You understand though that whatever vacation, the sick hours he lost, he could get all that back plus some. So it cost them more money. It cost the village more money because of the depravity and the stupidity of Keith Freeman, super stupid, and the other 2 or 3 goons. Tangique Miller and Janice Johnson. They're the worst. Good grief. I don't recall Jason House and Keanu Belcher being listed as persons of interest on the FBI subpoena because they're not. They're not on the FBI subpoena. None of them. But Keith Freeman, Tangier Miller, Super, Janice Johnson. Oh yeah. They all got to come. They're also listed in lawsuits that they're not winning. Oh my God. But people want to sit here and fuss at Kiana Belcher and Jason Howes and Brittany Norwood. The hell for? Ed Steve. These people aren't listed on FBI subpoenas either. So for every one complaint that these goons can bring up, I can throw out 2 or 3 lawsuits to debunk them. Funny how that works. Because they don't read. All right. It goes to show I'm not trying to even sit here and show a deference, but at the very least, be able to prove if they're under investigation by whom. We cannot prove that Keith Freeman and Tangier Miller and Janice Johnson are under investigation, that they're named in lawsuits, that they're losing, that there's sufficient evidence to show their wrongdoing, that they have fault. They're costing the village a lot of money because these lawsuits are going to start coming to some resolution. And who do you think are going to pay for these judgments? The village. All because these dumbass goons thought that they could do what they want to do and get away with it. While you got other goons blaming Jason House and Kiana Belcher and Brittany Norwood and Ed Steve, they bring blame for what now? When they're not even under investigation? I don't even think I recall seeing Ed Steve's name as a defendant in a lawsuit. Perhaps I can look. But I mean, he hasn't been sued and actually lost anything. And when Super tried to sue him, she lost. It was dismissed because of the sheer stupidity of it all. While she's the main subject of an FBI investigation. Good grief. Good grief. Yeah, I'm coming in a little savage on this one. Yeah, just have to deal with it. You'll be fine. Oh man, I can't understand that. All right. So he was relieved from paid administrative leave without any further action, was returned to duty on February 15, 23. Since the filing of the original complaint, the village has taken measures to ensure deposit of the delinquent plan deposits or contributions. A copy of Duval's affidavit is attached hereto as Exhibit H. However, to plaintiff's knowledge, not all payments have been made to date. Furthermore, the village has not resolved the underlying problem that causes the untimely deposits, and the problem of untimely deposits persist. So it was still going. And that was in Exhibit H. Finally, the village has not paid plaintiffs any of the statutory damages. Count 1, violation of the IWPCA. So they realleged paragraphs 1 through 31. Paragraph 33, they define the IWPCA. You guys can pause, take time to read that, but it's dealing with the wage theft again. Under the state statute code 820 ILCS 115/2. Here under the PCA, the plan deposits qualify as either wages because the deposits come from the affected employee's biweekly pay, or as wage supplements that are subject to the wage collection provisions of the IWPCA. So that law will still apply if it is considered wages or wage supplements. That's basically what that's saying. Let's see. What does it say? This count arises from defendant's violation of WPCA, and then the statute code is 820 ILCS 115, etc., for defendant's failure to fulfill their duties under the plan and ensure that the infected employees' monies or contributions were deposited into the appropriate accounts and or appropriate contributions were made from at least July 22 through the present and continuing to date, which would have been 2023 when this was filed. The village made deductions from the wages of the affected employees pursuant to the plan, failed to take appropriate measures to ensure that these monies were deducted and timely deposited, and or failed to make the deposits contributions into the affected employees' plan accounts. The affected employees were, are, and continue to be entitled to have the village deduct the specified amounts from their paychecks and have those deductions deposited into their plan accounts in a timely manner, which is no later than 13 days after the end of the pay period. You know what? If I were them, I would just be like, screw it. Just don't touch my check. Give me my whole check and then I'll do it. Oh my God. I would have just said, you know what? Y'all can kiss my ass. Y'all not touching my check no more. Nope. Nobody wants to read the definition of the word theft. Somehow money's still missing. No one's answering emails. Don't touch my check. I would have just stopped the deductions. Personally. I was like, nope, not taking no more money out my account, my check. Nope. Because, no, no. Defendants made deductions from affected employee wages deposited in these monies as authorized and instead kept the monies and or significantly delayed making the deposits or contributions. Y'all see that? They either kept the money and or significantly delayed the deposits or contributions and failed to make deposits or contributions in a timely manner. So they intentionally delayed when it did get deposited, it was delayed intentionally. And they simply either took the money and they failed to make the deposits or contributions to Nationwide. This is crazy. I would not have had my check deducted. Nope. I'll get my own plan and y'all can reimburse me from there. Oh my God. Defendant's failure to fulfill his obligations under the plan and make deposits or contributions to the appropriate plan accounts violates the WPCA, which requires payment of wages no less than 13 days after the end of the pay period. And plaintiffs and affected employees are entitled to recover the amount of any such underpayments and damages of 5% of the amount of any such underpayments for each month following the date of payment during which such underpayments remain unpaid. Plaintiff is also entitled to recover costs and all reasonable attorney's fees. Yeah, because they had claims that they couldn't pay that went to collections. So it messed up their credit. No, you're going to pay me for all that. Additionally, plaintiffs attempted to address this problem with defendants several times prior to the date the original complaint was filed. And you guys remember, I'm reading the amended complaint. There was an original complaint filed prior to this. This is the amended complaint. And the defendants continue to willfully refuse to correct the violations. Where an employer willfully refuses to pay, they will be, upon conviction, guilty of Class B misdemeanor where the amount at issue is $5,000 or less, or a Class A misdemeanor where the amount at issue is more than $5,000. Furthermore, each day that a violation occurs constitutes a separate and distinct offense. Offense, meaning you're violating a law, which is a crime. You still want to sit here and say that no one broke any laws? This case is still pending in court, people. This is still going on. Why not put a little pressure to figure out why is this not being resolved? This is still going. They still have upcoming hearings. This is crazy. Who child? Count 2. Violation of the Whistleblower Act. So this is the portion where the union president Duval alleges retaliation for disclosing information to a government agency where he had reasonable cause to believe that the info disclosed a violation of a state law. Duval emailed village officials and 2 village trustees about the village's conduct of deducting monies from the affected employees and failing to deposit or timely deposit those deductions. Defendants expressed the fact that they were upset with him for asserting that the village's conduct could be considered wage theft, even though it is by definition, and that he copied the village trustees on that email January 11, 23. Ah, Lord, why would they be upset for the trustees to be included? Don't you all want them included? Why would they be upset about that? Oh no. So that the trustees can cuss their ass out of the board meeting about it. Oh man, Kiana Belcher should have chewed their ass alive. All right, defendants threatened Duval with retaliation in violation of the Whistleblower Act. And you got the statute code stated here, 740 ILCS 174/20.2, by threatening Duval with discipline at the end of the January 12, 23 meeting, requiring that Duval and Cole be escorted out of the village hall by a police officer that Keith Freeman called and demanded that they show up to. I was like, you ain't finna bring me down here to have me kicked out. Kiss my ass. You better call me so I can record this. They should have recorded that. Everything should be recorded now. Just record it. You don't feel safe? Record it. That's it. You want to stand here and think you're going to come at me crazy? Okay, well, the entire world is watching. Good luck to that. That's the only way to go at this point, dealing with these clowns. Shortly thereafter, Duval was placed on paid admin leave and was under investigation for reasons. But sending the village inappropriate emails because Keith Freeman doesn't know the definition of the word theft. Duval interpreted the village's actions as a threat that was in retaliation for his repeated complaints about the village's failure to honor its obligations under the plan. Because, it's a legal binding agreement that could be used in a court of law against you, Keith Freeman, you dumbass. By threatening Duval and placing him on paid administrative leave for his conduct of disclosing what he reasonably believed to be violation of state law, defendants have threatened retaliation against Duval in violation of the Whistleblower Act. Duval is entitled to disclose to the village government agency info that is reasonably believed to be a violation of state law. Duval is also entitled to be free from the threat of retaliation for such disclosure because the Whistleblower Act is a federal law that, of course, is adopted on a state level. But it's still law. You sit here thinking you're above a law, Keith Freeman. That's laughable. When you gonna pay back the village robbers again? You're worse. He is the worst. Duval is also entitled to all relief necessary to make him whole, including but not limited to compensation for any damages sustained as a result of the violations, including litigation costs and reasonable attorney's fees. Wherefore, plaintiffs respectfully request that this court enter judgment in the amount of all deductions that were made from the affected employees' salaries and not deposited into the affected employees' plan accounts due to the plaintiff and or the affected employees as provided by the WPCA. Order the village to refrain from violating plaintiff's rights under the WPCA. Order the village to take the necessary steps to fulfill its past, present, and future obligations under the plan. Order the village to provide all info needed to the vendor of the planning, which was at that time nationwide. I don't know if it's now changed to something else. In a timely manner to ensure timely deposits or contributions into the affected employees' plan accounts. Award all statutory damages as provided by the IWPCA, including but not limited to interest. Enter a judgment in the amount due to Duval as provided by the Whistleblower Act. Order defendants to refrain from violating Duval's rights. This is sad. You got to have a court order some people that working for a government to not violate federal laws and protections that we all have as U.S. citizens. It's ridiculous. And this is what the goons want to defend. While some of them state that they took an oath to uphold the Constitution, they don't give a damn about somebody else's rights being thoroughly violated, though. Despicable. Despicable. Can't take the clown serious, though. This is why we leave the trolls underneath the bridge in the mud to wallow with the pigs that they all, I guess, obviously can relate to. I don't know. This is crazy. So under the Whistleblower Act, they wanted an order from the court to keep the defendants from refraining from violating Duval's rights under the Whistleblower Act. Award all statutory damages to Duval as provided by the Whistleblower Act, including but not limited to interest. Declare that the defendants have violated the WPCA and Whistleblower Act. Enjoin defendants from violating the IWPCA and the Whistleblower Act now and in the future. Provide any and all relief available to the plaintiffs under the IWPCA and Whistleblower Act. Award reasonable attorney's fees and costs to the union, to Duval, and any and all other such other and further relief that the court deems appropriate and just. Submitted by Susan M. Mata, one of plaintiff's attorneys. And you guys see the firm ID here, 32544. Well done. Dated March 22, 2024. Well done, Susan. Well done, counselor. And that is all for the amended complaint. Oh, man. I just want to show this here. This is there was a motion to dismiss naturally because reasons. Because, I guess they were also mad at the fact that, they probably didn't understand the definition of the word theft. Let me not say that. But, the defendant's attorneys filed a motion to dismiss. And here is the plaintiff's response in opposition to the defendant's partial motion to dismiss. And it's what it does, it kind of goes deeper into the law, cites case law as to why they're opposing that motion to be dismissed and asking the court to deny that motion to dismiss. So I'm not going to read the motion to dismiss. I'm just going to kind of skim over what the plaintiffs, being David Duval and the firefighters, the attorneys representing the firefighters, stated as their response to that motion. All right. So the beginning part is, good grief. Plaintiffs filed suit on January 23, 23 in the Chancery Division of the Circuit Court, basically about the theft of wages not going to nationwide, and of course the retaliation, violation of rights under Whistleblower Act for David Duval. Keith Freeman kicking people out of a building that he told them to come to for a dumbass meeting that could have been done over a phone. Are we all caught up? Hopefully we're all caught up. All right, so they listed some additional retirement plans, like the 457 retirement plan. Of course, they found out that the wages were being taken out of the firefighters' checks, and it was not going to the accounts that it should have been going to. Duval brought the concerns up, tried to fix it. Keith Freeman threw a tantrum like a petulant child because he failed to read definitions of terms. And they have argument here based on A2-615 motion test the legal sufficiency of plaintiff's complaint, asking whether the allegations in the complaint construed in the light most favorable to the plaintiff state sufficient facts to establish a cause of action upon which relief may be granted. A complaint should not be dismissed pursuant to section 2-615 unless it is clearly apparent that no set of facts can be proved that would entitle the plaintiff to recovery. So whenever you have these, civil procedures like this, whether it be a federal lawsuit or just a standard lawsuit in the court of law filed, most times the defendant's first thing response to the complaint is to file a motion to dismiss and then try to invalidate the merit of that case. So typically when the motion to dismiss is filed, it is basically the defendant's way of just trying to find some way to say to the court, well, you shouldn't take this seriously and it's not valid because there's no merit. There's no facts of the case. It's more of accusatory. That's always kind of that first angle. So don't get offended when the defendants file a motion to dismiss. That's standard. And it's typically, especially for civil procedure, and you're asking for damages because, no one wants to pay money. But that's to be expected. Most times, if the smart attorneys, what they will do is be prepared for the motion to dismiss with a response to that, which is what we're looking at here. And so either party, regardless of whether, because the plaintiffs could, let's say the defendants filed a motion for summary judgment, and then the plaintiffs decided to file a motion to dismiss that defendant's motion of summary judgment. Then the defendants will have the opportunity to respond to that motion to dismiss. That stuff can go back and forth all day. And sometimes it just stalls the case and adds on unnecessary time as well, because they're trying to avoid the inevitable. At some point, this case is going to have to get resolved, and somebody's going to have to pay some money. I don't think it's difficult for them to prove that there truly was wages being deducted, going to an account that was supposed to be for retirement plans and other accounts on the employee's behalf for insurance premiums and policies and those things, and it didn't make it there because the insurance company can vouch for that. So to say that there's no facts on that, when the insurance company can provide documentation, the employees can provide documentation money was deducted, and that this money went somewhere, and there was an agreement that the village of Dolton would ensure that it went to the insurance companies, and the insurance company said no, it didn't. And here's the proof. Most times, the motions to dismiss from the defendants are typically denied because there is a valid claim stated, there's sufficient facts, and then you have the law to support it, along with case law. That's why I said case law is imperative to have in these, especially in these types of lawsuits where you're alleging that state or federal laws even were violated. Oftentimes you have some case law here. So if you scroll down, that's what you see here. This is supposed to be Project 44 Inc. versus Four Kites Inc. 2024 Illinois matter here. You guys see that's case law. So, for them to say that, it should be dismissed under a specific rule or section, state law court rule, and it seems like section 2-615, that might be court rule. But whatever they're trying to utilize to say why the complaint should be dismissed, there are parameters that have to be met. And that's what this argument is. The motions test the legal sufficiency of the plaintiff's complaint. They're asking for this motion to be dismissed by saying that there is not enough sufficient facts to establish a cause of action upon which relief should be granted, and that there are no set of facts that can be used to prove what they're complaining about, and that would entitle them to any type of recovery. That was, I'm more than likely sure what that motion to dismiss was without even having to read it, based on the argument of the response here. So, under the standard, plaintiff's claim under the IWA should not be dismissed. In addition, defendant violated Illinois Supreme Court Rule 23 by citing unpublished appellate court orders. By citing unpublished, God, unpublished appellate court orders in its motion. Good grief. You guys have to understand that there is some predicates to determine what is case law. You can't cite unpublished appellate court orders. Lord, they did it. This is unbelievable. What are the attorneys? Oh man, if it's Olderson, I'm going to be so mad. If it's Olderson, I'm going to be so disappointed if you, Bert Olderson, filed that motion to dismiss and you're citing unpublished appellate court orders. I'm going to be so mad, bro. So mad. Who was the attorney on that motion to dismiss? Please tell me it was those incompetent F's over there at what's that? The one I don't like. Ugh. Delgado Law Group. I can't stand them, bro. I can't stand Delgado Law Group. All they do is just leech off of communities, billing hours for an absorbent amount of money while still failing to cite real law. You citing unpublished appellate court orders? Please tell me that was not Bert Olderson. If it is, I'm going to be so disappointed. So disappointed. I can't believe this. Oh man. Well, just when you didn't think they could get low, they get lower. That would be so wrong. Unbelievable. This goes to show why it's imperative to have an understanding of what case law is and precedents. God dog it. I thought I heard it all, but no, no. Paragraphs in his brief supported by these citations should be stricken because it's offensive. He's citing unpublished appellate court orders. Unpublished. Come on, yeah, strike this off from the record because now you're just insulting us all. All arguments supported by the unpublished order should be stricken. If, for the sake of argument, none of the defendant's argument is stricken, plaintiff's stance remains that its claim under the IWA should not be dismissed. They're saying, listen, the claim is made under this law here, under the IWA. You got to have some sort of merit to state to the court with other law to oppose that claim as to why it should be dismissed or should be invalidated. You're citing unpublished appellate court orders. Oh, man, that was a good laugh. All right. Defendant violated Illinois Supreme Court Rule 23. Oh, man, they did. They did. In support of his motion, defendant cites two unpublished appellate court orders, Miranda v. MB Real Estate Services, LLC, 2016 Illinois Appellate Court, and Dabbs v. Peoria, did I say it right? Peoria County, 2020 Illinois Appellate Case. Illinois Supreme Court Rule 23E1 renders non-precedential, meaning precedents, no precedents established, such orders except to support contentions of double jeopardy, res judicata, collateral estoppel, or law of the case. A non-precedential order must contain a notice on the first page effectively warning the reader of its limited usage. Non-precedential orders entered on or after January 1, 2021 may be cited for persuasive purposes. Both Miranda and Dabbs were entered before January 1, 2021 and may not be cited even for persuasive purposes. Jeez! You can't even use those damn cases to be persuasive, to help enhance your argument. Hell no. Indeed, orders predating January 1, 2021 should not be cited for any reason beyond Rule 23's exceptions. So when you go to the court rule, you read the exceptions, and then it tells you what cases you can and cannot cite as case law under this exception of that court rule. When I say that when it comes to certain matters regarding the court, it is very specific in black and white. It is not left to your interpretation. It is exactly as it is written. It is to be interpreted and defined as it is written. Very specific. And if you don't understand it, then you have applicable case law to help you understand how that law is interpreted. Not based on your opinion. Especially if you did not go to law school, no one cares. You got attorneys doing this stuff, though. That's so dirty. That's a dirty tactic. Forget the court rule. So the attorney was either incompetent, they had a brain fart, or they just didn't care. They're reaching. Oh, come on. You violated court rule. They should have been admonished for that. The judge should have get it on them about that. They should know better. So let's scroll down. Parties may also may not raise attention to unpublished cases in order to imply precedential value. So by saying I'm citing this case that shows precedence based on what I'm arguing, based on the law. No, you can't say that something is precedence when it's not. That's the same thing I said about, what was that other case I said that I put up a post about it. It wasn't to be funny. Is it the Shay Hall or somebody versus YouTube? It was not to be funny. But his case is not case law. It's not precedence. It was not to be funny. Legally, that is a real thing. You got to have Case law cited as case law. Case law is law. So you can't just throw out a case and bring that up to say, this is how this is going to be handled if I file a lawsuit. First of all, his case is still active in court. Secondly, there's no ruling on it that's been rendered from a jury or judge. And even so, it would still have to be established as case law, as precedents. You got rules and laws on that. That was not to be funny. That was being honest and truthful. Oh man, it's not to even invalidate his case. It's just that it's not precedence. That's not case law. So hearing people use that open pending case in court, trying to make it seem as if it has some precedential value, it actually does not help his case either. Because the judge is going to be like, listen, I'm seeing stuff where your case is being used to establish other lawsuits here. And this isn't case law. There's no precedential value to this. What's going on? It might not help him for people to keep using his case, trying to cite it as if it's proving some. It's not case law. It's not precedent. It has no precedential value. And plus, it's still pending. Let that play out in court, whichever way it goes. But that is not precedent. You can't say based on his open pending case, this is how all my other cases is going to go. Everybody should be scared. No, we're not. I'm not. I'm laughing at how you're hurting his case, if anything, by saying that. It's so ridiculous. It's not even funny. And yet it is. I just don't get it. I don't even know what I don't really watch his videos like that. I don't know if he's ever used that, his own case to try to sit here and give precedential value to it. But if he has, you might want to stop doing that. Because it's, as you can see, it goes against a whole ass court rule. Don't do that. Just let your case finish playing out. If you want to talk about just overall, certain points in it. But don't even divulge deep into it, because it's not going to help you. It's not. And I'm not trying to look out for one side or the other here. I don't really. YouTube is a large corporation. They got a lot of fucking money and they get on everybody's nerve. But if you really want to help your case out, tell people to stop trying to sit here and cite it as precedence. It's not precedence. And that's not going to help. It is a violation of court rule. So oh, Lord have mercy. Lord have mercy. So as you can see here, here's a case where you can learn something from that and stop doing that. It's not helping you. It's not helping you out at all. Not at all. All right. Let's see here. Even if it were appropriate to cite Miranda and Dabbs under Rule 23E, defendant disregarded the rule's requirement that a copy of the order shall be furnished to all other counsel and the court. And this is Illinois Supreme Court Rule 23E 1. So this is the state Supreme Court rule here. Your case is still active. There's no order in it. Other than I think it was an order to show cause. But that is not a ruling. It's not part of the resolution of the case itself. It was just an order to show cause. That's it. Based on court rule, you don't give your case precedential value. It's going to hurt your case. Yeah, maybe that helps him out. I don't know. Whatever. It's sad to see that, because it's simply, these are the things that, lawyers who attended law school will know, especially if they're smart and competent. I'm still curious as to who filed that motion to dismiss. Because if Bert Alderson, if you filed that motion to dismiss, bro, stop it. That was horrible. Come on, you don't take that angle. Yeah, pissed off all the courts. You did that. That would be terrible. All right, we're gonna move on. I'm gonna scroll down. However, the appropriate remedy. Y'all see, I'm just kind of reading tidbits out of this here. There's a lot of legalese in this, a lot more case law being cited here, court rules being cited. As you all can see here, I'm just kind of reading some statements that stand out to me that I believe would be helpful in many, many other areas. However, the appropriate remedy for the improper use of such cases is to strike such references from the brief. And then they cite Wallace v. Country Mutual Insurance Company 309 Illinois appellate case from the second district in 2000, where that actually occurred. Specifically, paragraphs including citations in violation of Rule 23, Green v. Papa, 2014 Illinois appellate Fifth Circuit. And if that's what has happened, and you're giving precedential value to a case where by court rule and law should not have it, please expect part of your filing, your pleading, your documentation to be stricken from the record. Because according to court rule, that is the remedy for that. So you might want to have other case law that is precedents cited in your court filings, in your pleadings, to whomever hears this message. Not saying it to one person. I'm just saying, citing that case over and over again, that it does not have any precedential value, hurts his case. And if there is any improper citing of a case that is not precedence, can and will be stricken from the record. And the attorneys for YouTube will know that. Please believe me when I tell you that. They will know that. So you better have it written better. You write it better. Because if not, half that is going to be stricken off the record. Because you got other YouTubers running around here talking about your case being case law and precedents and stuff when it's not. It's not by court rule. And then all that gets, half that stuff gets stricken off the record from your document, from your pleading. Is that what you want? Come on now. Yeah, I mean, if that's what you want, then whatever. It's on you. But that's not how it works. That's not how it works. That's why I posted that. I hope that was a warning. And to anybody, I want to file lawsuits all over the place because everybody want everybody's channels to be stricken and videos be taken down. Nobody knows what they're doing because no one's an attorney. But yet and still, things like this is what you do learn when you go to law school. Court rules. And things are misappropriately cited and being weaponized. And that's not going to help you in court at all. Jesus Christ. All right, we're going to move on. I just thought I had to point that out. So they speak to Duval has a cause of action under the IWA, and they go further into that. And they explain the state statute, why, they're asking the court to basically dismiss that motion to deny the motion to dismiss. And they go into, based on court rule, why. Defendant relies on case law cited in violation of Illinois Supreme Court Rule 23. Yeah, that's gonna mess up a lot of cases if you're doing that. Just don't do it. Don't do it. And if you're an attorney, understand that judge will admonish you in a minute. If you are an attorney, and I mean you're a lawyer that went to law school, you graduated, and you got a bar license, and you're practicing law, and then you go and violate a very basic court rule like this, that is state Supreme Court rules. Okay, we're not talking about like a county level thing here. We're talking about state Supreme Court rules. Something you learned probably by year 2 of law school. And you go in here and forget you went to law school and you go and violate a court rule when it comes to citing case law. And you say, that's basic fundamental. That's what you learned by year 2 of law school. Because that's how you help to prepare, pleadings and briefings and motions. And these complaints, you got to have the appropriate case law cited. So that's just a part of actually drafting the pleading. The court understands that attorneys want to be overly zealous for their client, but it should not be at the detriment to violating a law or court rule. And if it's done repeatedly, which it sounds like it was, all you're going to do is piss the judge off. And if you got a federal lawsuit, the federal court judges don't play. Let me tell you that right now. They don't have time for all that nonsense. So you better go in there and know what you're talking about and have a competent attorney that knows what they're talking about. Because the village Dalton's attorney wrote that motion to dismiss. Oh man, I'm just hoping, boy, I would be so disappointed if it was Bert Oderson. He knows better. Let's just hope it was that old incompetent Solomon. This is insane. Oh Lord have mercy. Or Delgado Group. Because yeah, I can expect some lowball dirty tactics from them. They're the worst. An employer may not threaten any employee with any act or omission if the act or omission would constitute retaliation against the employee under this act. Are you serious? Trying to say that he doesn't have the legal standing to say that he was retaliated against under the Whistleblower Act. That's what they had motion to dismiss. Yeah, this is man, this is something else. If I'm the attorney writing this response, in opposition to that motion to dismiss, you got to know she's got sassy a few times in here. And I can tell she is mad. That attorney is mad as hell. Yeah, I'm not gonna read it all. I'm just kind of scrolling through. So in case you all want to read it, you can. But trust me when I tell you, the attorney that wrote this is pissed off. She mad as hell. Oh my God. So then they have another test here that states in determining whether a statute creates an implied cause of action, courts apply a four-factor test of whether one, plaintiffs are members of the class the statute was intended to benefit, two, the statute was designed to prevent the plaintiffs from suffering the injury they incurred, three, the statute's purpose is consistent with the creation of a private right of action, and four, it is necessary to imply a private right of action to provide an adequate remedy for the statutory violation. Oh my God. So, unquestionably, Duval is a member of the class. He had to fit these parameters basically to say that there is an implied cause of action as well, especially when it comes down to you saying someone retaliated against you, they put you on leave, they did all these things simply because you brought up a concern about money coming up missing because theft, Keith Freeman, that was not making its way buying through a contractual agreement to an insurance company, and him bringing it up incurred all that nonsense from Keith Freeman and Super Stupid and Janice Johnson and Tanginique Miller and anybody else that was in that dumbass meeting. And then have them escorted from the building, a public building, really accessible to the public. Tax dollars pay for that city hall. Fuck out of here. This is crazy. I know this attorney was mad as hell. It's like, this is almost like writing a paper for law school. To sit here and make this argument. Oh my God. Defendant asserts that Duval failed to disclose to a government agency information that he believed was in violation of the law was as required by Section 15B of the IWA. Oh my God. Man, I'd be bad as hell writing this. Oh my goodness gracious. He didn't fail to disclose to the government agency info he believed was in violation. He told them in emails. It's something else. I can't believe who wrote that defendant's motion to dismiss. That was terrible. Man, this attorney is on it. If just take some time to read this. I promise you it's gonna be funny. You're gonna laugh. Duval did not merely inform his supervisor of improper or unlawful conduct. Rather, Duval notified his immediate supervisor, Fire Chief Peter McCain, defendant's director of administration Janice Johnson, village administrator Keith Freeman, of suspected violations. Because his ongoing attempts had failed, he further escalated his concerns properly by disclosing the suspected violation to the highest government officials of the defendant's jurisdiction, exercising general supervision and control of the fire department and finances. The village of Dolton's chief executive officer, Dam Dam, and village trustees Jason House overseeing finances and Kiana Belcher overseeing the fire department. Accordingly, Duval meets the standards under Brahmi, which is more closely analogous to the case at bar. So they said he didn't tell nobody. The attorney right here said, yes, he did. Not only did he tell somebody, he did it in succession. He told the first layer of people that, should have been told, kind of like going up the ladder or the chain of command. So he tried to tell these goonballs, they didn't listen. So he went above that and then went and told the trustees and at that time, ex-mayor, super. That's it. It's that simple. How many more people should he be telling to fit the defendant's narrative of, okay, yeah, he did tell somebody? Are you kidding me? Yeah, I'm telling you, if you read this, you're gonna laugh. You're gonna be like, man, this is so crazy. She had to write this. Wow. Bless your heart. Oh man. So of course he got threatened with retaliation because he's questioning where money is going that's coming up missing that belonged to the owner of that property, Keith Freeman. So yeah. And if you did not try to resolve it, that means you intended for the property owner to not maintain possession of their property, Keith Freeman. That's the definition of the word theft. God. Where y'all get him from? Other than the village of Robbins. Well, he was thefting over there too. More theft occurred over there as well. You don't hire someone that's already being investigated for theft and a judgment was issued against him for theft. He owes the village of Robin $90,000. He owes them that through a judgment from a court. What the hell? Yeah, no, that's the person to hire in as a village administrator. Yeah, okay. God. That why is anyone shocked that he was indicted by the FBI? Because I'm not. I'm expecting a superseding indictment, as a matter of fact. He is the worst. Freeman raised his voice and swore at Duval repeatedly. So all that verbal abuse for nothing. You're a grown man. Why is it that she keeps these punks around her that sit here and yell and scream at other grown people? Keith McChicken Nugget yelling at his employees, threatening one of them to go outside and try to fight him. Why? It's like punching a bag of McFrosty. What we doing? Then you got Keith Freeman sitting here yelling and screaming at two grown men because at the end of the day, where's the money? Where's the money, Keith Freeman? Where is the money? Fuck out of here. This is insane. This is insane. All right. So they basically having to defend, what they stated in the amended complaint on behalf of the petitioners. The attorney does a great job. You guys look here. A threat, by its very nature, does not require specificity. A threat is a declaration, expressed or implied, of an intent to inflict loss or pain on another, an indication or an approaching menace, the suggestion of an impeding detriment, or a thing that might well cause harm. He had to break down the definition of the word threat. Yeah, come on, man. She was mad. Ooh, this attorney was hot. She said, you know what? Since these assholes don't know the definition of the word threat, let me help them out. I feel your pain, girl. I feel your pain. Sometimes we just got to break down definitions of terms. Y'all, they got some U.S. Supreme Court rulings. They recently rejected the use of this standard of harm in discrimination claims under Title VII. Muldrow v. City of St. Louis, 144 Supreme Court 967. This is a 2024 case. Muldrow left intact White's broader definition of materially adverse for retaliation claims, though in dicta referred to White's reasoning as frankly extra-textual. Okay. Yeah, that's a lot of illegalese. Sometimes I have to look this stuff up. Not even gonna lie. I didn't go to law school. So I had to look this stuff up. But I could tell that this attorney was mad as hell for having to type up this damn document. Ooh, child. You got to give the definition of the word threat to other attorneys in the court. Yeah, you mad. You mad. I mean, rightfully so. It's in here trying to say this should be dismissed because they failed to cite a claim. I'm sorry. How many laws did you just not read in my amended complaint again? Child boo. All right, we're gonna read the conclusion. Susan M. Mata is pissed off, rightfully so. Conclusion: the amended complaint states a claim on which relief can be granted. The defendant's conduct toward Duval constituted an actionable threat of retaliation under the Illinois Whistleblower Act. Defendant failed to properly support its motion, and the motion must be denied in its entirety. Plaintiffs request that all paragraphs containing references or citations to cases that violate Illinois Supreme Court Rule 23 be stricken from the motion in their entirety, or in the alternative, that all such citations and arguments be stricken in their entirety. Furthermore, defendant's motion should be denied in its entirety, and plaintiffs should be granted all relief requested and all relief deemed necessary and reasonable by the court. Ah, man, Susan M. Mata. Ooh, well done. Well done. I feel your pain. I had to look up the definition of the word theft because, somehow this administration and former administration, thank God, former. Thank God for former. Super stupid and her goons don't read well. Mm-mm-mm. All right, so after Susan M. Mata just kind of threw down a hammer here. Listen, if you need an attorney and you got a case pending, you want to sue everybody and their mama, you might want to contact Susan M. Mata. She bad to the bone. This was well written. Well written. And of course, once again, I like seeing the firm or the barcode or bar license number, firm ID number here. That's fine. I'm all good with that. I do want to kind of touch on the man, yeah, this is something else. This is something else. Want to touch on the Illinois labor just real briefly. Here is the Illinois Labor Relations Board State Panel, their recommended decision order. So, of course, they had to file a complaint to the Illinois Labor Relations Board when David Duval was put on paid administrative leave for no damn reason and was being investigated because Keith Freeman doesn't understand definitions of terms. So, his case number is S as in Sam, C as in cat, A as in apple 24-093. And I'm just gonna kind of scroll down so you guys can see this information. I did read over it. It kind of resembles the amended complaint, except this went to a specific governing board. And they have board rules they incorporated throughout the recommendation and order here to justify what they decided on. So, also, the defendant did not have certain documents and motions filed in a timely manner. They also failed to file an answer. I mean, if you file a complaint against a party, the other party has the right and opportunity to file a response to that, but they have to do it within a certain time frame, whether it's in a court of law or with a judicial hearing, or if it's through some government governing board or body with an administrative hearing. You still have timely measures you have to meet, and you don't file a response, it kind of gives off an indication that, whatever, I don't care. So you don't have 1,000 years to do it. And if you don't file it within a timely manner and there's no, exigent circumstances or reasoning to justify why you could not do it in time, most often times, whether it be the judge over the board or the person serving as the judge over the board in the administrative hearing or the judge in the court of law, they're gonna, at the very least, they're gonna proceed forward. So, no answer having been filed by the time required by the rule, charging party filed a motion for default order, which is standard. Just like filing a motion to dismiss after you file a complaint. That's, kind of standard. But it's the petitioner's job to ensure that they have merit to their case and that they meet their burden. And for a civil procedure, the burden to meet is a preponderance of the evidence. So you just need to be 51% convincing. Is it more likely than not that the defendant you're accusing of these, claims that you're stating here actually committed the offenses, and are you entitled to the relief that you're seeking? That's what that comes down to. So that's a tidbit for everybody trying to sue everybody. Tell you right now, you come for Lady Luck Club, you better make it good. All right. They had an order to show cause required. They didn't do that. Oh, the responders just did nothing. Come on now. They didn't do nothing. They just village dog. Oh, it just made it easy. Okay. So let me see. Responders counsel by October 7, 24 is Oldison, Murphy, Frazier, McGrath. Okay. Were they the counsel though for that amended complaint? Did they file that motion to dismiss in the lawsuit? That's what I'm curious to know. Or was it Delgado Law Group? Because if they filed it, then that's I can understand the incompetency that Susan M. Mata wanted to express to the court in her response to the dumbass motion to dismiss. If it was Oldison, I can't explain that. It's almost like, what kind of moment were you having, bro? But I think it was Delgado Law Group. I want to say it was them, but it's just being positive. But as you all can see, I'm fair opportunity fuss. I'm gonna get my mama fuss mode on, no matter who it is. Doesn't matter who it is. So, oh my God, the village went from a general fund balance of 5.61 million in 21 to a deficit of 3.65 million as of May of 2024. Oh my God, it was Delgado Law Group. Look, y'all, the position statement also alludes to a change in legal representation. The position statement states that prior to OMFM's appointment, Delgado Law Group was assigned as legal representative of the village. So the Delgado Law Group filed that dumbass motion to dismiss in the actual lawsuit. Look at that. Didn't I tell you all Delgado Law Group sucks? Didn't I tell y'all? Lady Luck Club said it for many months. Delgado Law Group suck. They're incompetent and they're just leeching off of communities in the South suburban area in Illinois. Period. The end. They're not giving you your money's worth. They're filing dumb claims and lawsuits. They kissed the ass of Super Stupid for 4 years. They did nothing. They were not worth all that money that now a school board is paying them. Why is a school board paying them to do anything? The best way for them to become non-existent, stop hiring them. Get another attorney. Why is the school board paying them? Because if you can't tell how horrible they are in their pleadings, in their documents, in the motions that they're filing, then I don't know what else to tell you. Sometimes it's just a matter of reading being fundamental and understanding what you're reading. Because everybody keeps saying it now. It's funny how this it's catching fire. But understand what you're reading to. That goes hand in hand. But hiring the Delgado Law Group is a waste of money when they can't even file a proper motion to dismiss. Jesus Christ. Oh, they're the worst. They are the worst. I told y'all they were awful. Now you all get to see that. And I'm sure other attorneys recognize that too. Like, incompetent. Watch over here. Oh, man. They're the worst. Delgado is the worst. Oh, man. All right. So clearly they filed that motion to dismiss in the lawsuit. They were also representing the village at the time that this administrative hearing was going on, where certain documents needed to be filed, such as a response or a motion or a response to these motions. They were too busy trying to kiss Super Stupid's ass. They didn't actually do their job they were hired to do. They didn't care about the village general fund balance going from a surplus of 5.61 million to a deficit of 3.65 million. People keep asking, well, how did that money go? Where did it go? Perhaps you all should be asking Super Stupid that, because some of that is in those credit cards that was misused by her and her goons. Math is fundamental. Read. Clearly, a lot of this money went to Delgado Law Group to pay for their bum ass legal services. Did you all not see the billing hours, the billable hours that were paid by the village to Delgado Law Group and all of those warrant lists? Did y'all miss those totals in that? That's a lot of money going to a law group for them to do nothing. They got a lot of money. They got paid millions of dollars from the village of Dolton. Just leeching everybody dry. That's not something I have to make up. That's in warrant lists. It's in those budget reports. Call them budget reports, y'all call them warrant lists, whatever. It shows how much they've been paid, and you can go back 4 or 5 years to see and total that up. And of course, with Super Stupid sitting there bragging about getting lawsuits, seems like all they did was stay in court and bill hours against the village of Dolton to do nothing, to file bogus motions that violated Illinois State Supreme Court rules. Now tell me if Delgado Group was really worth that money again. Their motion violated Illinois State Supreme Court rules. And it's how many of them in the Delgado Law Group? Like 5 or 6 of them? Plus some? And they can't write a motion that does not violate a state Supreme Court rule? Get the fuck out of here. This is insane. Oh, man. All right, so let's scroll down to the bottom. You got your issues and contentions. The issue whether the late filing of the answer to the complaint is excused, and therefore whether the answer filed on October 7th should be allowed. That is kind of what they're contending here. Discussion and analysis. Of course, they're citing board rules. They have case law. Ooh, child. Lots of legalese. This is 14 pages long. So what it comes down to is, they went through the proper channels. Aside from going through the court of law, the firefighters, Dolton firefighters, went through the labor board. They're also unionized, so it's kind of an expectation that they would go through the labor, labor union, or the labor board, because that union would fall under this particular governing board here. So when you have these types of issues, when there's an attempt to arbitrate, you can kind of expect that complaint to go there. But if it gets to a point where, clearly Delgado Law Group wasn't even responding to anything regarding this administrative hearing, but yet they filing motions in court in the judicial hearings that violated court rules. So, it really left them no other choice but to have to now file an official, complaint with the court. So you would think that this would be the first main, action that they would take when there is a serious, violation and complaint from a labor union, whether it be the police department or the firefighters. But Village of Dolton, Delgado groups, they didn't respond. They didn't care. So now here we are. A lot of the information here, of course, you will find in the actual amended complaint. It just kind of reiterates their concerns. You guys see here on May 20th, 24, charging parties representative Susan Mata emailed respondents counsel Nelson Jaworski about selecting an arbitrator. So they tried to arbitrate. Nelson Jaworski responded to Mata's email reference in paragraph 16, informing Mata that respondents village board had challenged the authority of Nelson Jaworski's firm to represent respondent, and that Nelson Jaworski had withdrawn her appearance on behalf of respondents. So she wasn't even their attorney. Nelson Jaworski wasn't even the attorney when the firefighter rep Susan Mata, who wrote that awesome response to the motion to dismiss, she lit their asses up. Oh man, she reached out to them about an arbitrator to try to arbitrate. And she emailed the attorney that was allegedly on record for had, did an order of entry. And then Nelson Jaworski emails back, says, well, I had to withdraw because they challenged my authority to be an attorney. how janky this stuff was getting here. This is crazy. All this chaos and confusion on the super stupid. This was her administration. She did it. Oh man, this is something else. Oh man, so they tried to negotiate. I do believe that, like I said, something came down the pipeline with an actual collective agreement being signed towards the end of last year. But with Jason House being pro tem, it wasn't even involving super stupid. That's what's so crazy about it. On May 28, 24, Charging Party's representative Adam Farage met with respondents Fire Chief Pete McCain and Village Administrator Keith Freeman, advancing grievance number 24-001 to the third step of the grievance process. During the grievance meeting referenced in paragraph 24, respondents, ex-mayor Super Stupid, interrupted the meeting in a hostile and profane manner because she is ghetto as hell. She told McCain to run his department the way she told him to, and reminded Freeman that she had instructed him not to negotiate with the charging party. Because I guess some voice in her head told her she went to law school. That's pretty stupid of you, Super Stupid. Y'all see why I call her that? Super Stupid, behaving very stupidly. Like this could have been resolved with an arbitration, but no. You all can see here. Here's what happened. And so for the dumbass goons that still don't read, here you go. She did not try to negotiate a damn thing with the firefighters. She's interrupting meetings, using profanity, being hostile. And I use profanity as my channel, not in a meeting with firefighters. Because she walks in, supposed to be somebody's mayor, interrupting the meeting in a hostile and profane manner, telling the fire chief to run his department the way she wants him to do it, as if she's the fire chief. And reminded Freeman, who at this point had already flipped on her ass, because, he doesn't want to go to prison, not because he truly meant it. And reminded Freeman that she had instructed him not to negotiate with the charging party because reasons. By its acts and conduct, as described in paragraph 14, responded unilaterally ceased paying for unit members' insurance as provided for in the CBA, the collective bargaining agreement, that's what CBA is, without notice to or bargaining with the exclusive bargaining representative over its decision or the impact of that decision. So, respondent being Village of Dolton, spearheaded by Super Stupid. You all want to see what she's done? Here it is. Respondent unilaterally ceased paying for unit members' insurance. Who gave her the damn authority or right to think that she did not have to pay their insurance again? When you have a whole agreement, a legal binding agreement that can and will be used against you in a court of law in place, signed by both parties here. Who told her she could do that shit? Explain that to me. Because if you're charging into a meeting saying, run the department the way you want them to run it, and that they're not to negotiate, then why is it hard to believe that she told them to stop paying their insurance? See, when you're tapped into this reality, if thou have a mind that is still here in this reality on earth, and you clearly read the words on this paper, her name is right here, clear as day, black and white. And yet, dumb goons want to sit here who live under bridges, rolling in mud, and say, she didn't do anything wrong. It's not her fault. What trustee told her to do this shit? Please give me the name of the trustee that told her to run in here and interrupt this meeting in a hostile and profane manner, told McCain to run the department the way she told him to, and reminded Freeman that she had instructed him not to negotiate with charging party. Which trustee told her to do this? Which trustee's fault is this again? Because I don't know. It's not Kiana Belcher or Brittany Norwood or Ed Steve's fault or Jason Howe's fault. This is not, nope, she did this by her damn self. She's not taking any leave from anybody. She did this on her own. People want to know what she's done because they failed to read shit. Here's what she's done. Who told her to do that? She did. Her and the devil. And her and the devil are both a liar. You and the devil are a liar, girl. This is not something that a trustee shares blame in. See, I'm here for this all day to debunk the stupidity of it all. When goons and illiterate morons want to sit here and try to couple trustees down to everything that Super Stupid did by her damn self. And she dares not share that spotlight. That's fine. It comes to something like this. Yes, this is all your fault, Super Stupid. You did this by yourself. Happy to say that. Yes, I am. You did all this by yourself. You told them not to negotiate. You are the one that ceased paying for the unit members' insurance because you were mad at the world. You were losing. Keith Freeman flipped. He's still probably gonna go to prison, but you know, at the time he thinks he's not. So let's let him think that so he can keep cooperating, just for the benefit of getting information out of him to help the FBI. That's it. I don't think you have a choice, Keith Freeman. I'm just gonna be honest with you. You don't have a choice. You can either cooperate or you can face a lot more charges. That's on you. But no one told her to do this. She ran ahead and did this on her own accord. Yes, she did. And it's all her damn fault. See what happens when you just lose your mind. She lost her mind 3 years ago. She's done. All right. Recommended order. It is hereby ordered that respondent Village of Dolton, its officers and agents shall cease and desist. And when you say cease and desist, this is it. This is how you say it. This is how it's spelled. It's not decease and desist. It's cease and desist. Cease, not decease. Decease is death. Someone's dead. Cease means to stop. Desist, refrain. Please do not make me have to define those two words. I'm talking to the Goons LLC. I'm not talking to the LLC because we read up in here. I'm talking to the Goons that keep saying decease and desist. Yeah, people making threats using terms that aren't even accurate. Decease and desist. No, it's cease and desist. What the hell? Lord. But you know attorneys and judges again. Oh man. None of them told you to read a book? Okay. Child. Yeah, I clown the Goons all day. I'm here for it. I'm here for it. They can kiss my ass. All right. Failing to bargain collectively and in good faith with the charging party with respect to wages, hours, and other terms and conditions of employment of members of the bargaining unit in any like or related manner, interfering with, restraining, or coercing their employees in the exercise of the rights guaranteed them in the act. Take the following affirmative action necessary to effectuate the policies of the act. Restore the status quo ante as it existed as of January 10, 2020, with respect to paying group health insurance premiums, including payment of past due or omitted premium payments, and including any increases over pre-January 10, 2020 rates provided for in the collective bargaining agreement on behalf of each bargaining unit member. All right, restore status quo ante as it existed for dues deducted, make whole the charging party. I'm just kind of summarizing each one now. Make whole the charging party and any employees in the bargaining unit represented by charging party who were adversely affected by respondents' failure to pay group health insurance premiums and or failure to remit union dues deducted. They were taking out union dues as well. I forgot about that. They were taking out union dues out of their check. Oh my God. Then he caused some of these people to end up having collections. Now the credit is jacked up. No, you finna restore my credit. I want you to send a letter to Equifax, TransUnion, and Experian. and tell them that you're paying anything that needs to be paid to get my credit back in order. When I'm done with this, I want my credit score to be at 830. They would have to pay me back something big. We not taking peas and carrots. Sorry, y'all gonna have to pay that money. And this is why I said the village of Dolton needs to go after Super Stupid for some of this. So whatever new job she gets, get that damn check garnished. Don't be scared. Have a spine. That is how you move forward. By lessening the blow of what you're having to deal with financially, that's sure to come through many, many judgments. There are a whole lot of lawsuits that are still pending against the village of Dolton. Do you really want to sit here and keep shoveling out public tax dollars without at least attempting to try to recover some of this money from her and having it come out of her personally? She gets a new job, get that damn check garnished. The end. Whatever job she gets. Then, it's that easy. And show me a law where that can't be done. Because I can show you a couple that can. Good grief. Upon request, bargain in good faith with the charging party, post for 60 consecutive days at all places where notices to employees are normally posted. Sign copies of the enclosed notice. Let's see, did I skip one? In a posting at all places where notices to employees are normally posted or by means of a written communication delivered or mailed to each individual bargaining unit member. So basically, post up posts that's supposed to be posted, and notices that's supposed to be posted. Make sure that they're posted for 60 consecutive days at all places. The signed copies of each notice enclosed. So there were some notices, I guess, attached with this. Notify the board in writing within 20 days from the date of the board's decision in this matter of the steps the respondent has taken to comply with the order. You don't have a choice. That's what they're saying. Exceptions. And then they have pursuant to section of the board's rules. Oh, Lord, that's a long code. Parties may file exceptions to the administrative law judge's recommended decision and order and briefs in support of those exceptions no later than 30 days after service of this recommendation, similar to how it goes with filing an appeal or some sort of objection, right? Except in this matter, they call it an exception because they mean what they say on this, and they're not really giving you a chance to say, I'm not going to do it. And here's why. Now you don't have a choice. So, and then of course, they don't just accept it, they just review it, and then they decide whether those exceptions should be passed and included in the recommendation and order. So within 7 days from filing of cross exceptions, party may file cross responses. So of course, like any other motion to dismiss, from either party also has the right to file a response. So you file the exceptions, file responses must be filed, and then they give to the council that it has to be sent to, the address, the email. Oh man. And then they decide upon it, I guess, in a separate administrative hearing. And this is it. Issued at Chicago, Illinois, this 23rd day of October 2024. This was last year, guys. State of Illinois Labor Relations Board State Panel. Donald W. Anderson, Administrative Law Judge. Awesome. And here is the notice that is supposed to be posted up. And you guys can see it's 2 pages. And it's basically summarizing what they are ordered and mandated to do by the board. And of course, if they don't do it, then they go to court, and then the court of law tells them to do the same thing. Oh man, and then they get fined. You can get fined. You can suffer heavy penalties if you don't do this. Which is why it still baffles my mind why anyone would try to give Super Stupid any leverage in this when her failure to follow laws, rules, court orders, judgments, anything, knowing that it's going to cost more money as a repercussion of the action or a consequence of such, somehow they just think it's okay, or it's some trustee's fault that they hate. Because this could be a financial penalty if it was not done. If all of these things were not done as listed here in this notice. They could go to court. The board can fine them, heavy penalty, and then go to court. And then of course they suffer more, you know, consequences through a judgment, costing the village of Dolton more money. And you got clowns that thought she was a good fit. she, she's a leak. She's draining money that going towards dumb things that if she would have just acted like she had a partial brain, like 50% of her brain, and at least allowed the arbitration to occur, probably would have, avoided a whole court case. But whatever. She had it coming. All right. So y'all, that's pretty much that. Um, and then this is the last thing I want to go over for this video. Because we're hitting 2 hours here. I know it was pretty lengthy, but it's good. You guys put this on 1.5 speed. That's all I can say to do. I just got to go over this because I have not come across this until I started searching on the collective bargaining agreement that I still have not seen. So if you all can see this is a case, Gordy Taylor v. Village of Dolton, Illinois from 2017. It went to the U.S. Court of Appeals in the 7th Circuit. Number 17-1097, decided December 11, 2017. And of course, when you go to the appellate court, you have like a panel of judges that helps to make the decision. Gordy Taylor was a black firefighter, formerly with the Dolton Fire Department, asserts claims under Title VII for discriminatory discharge and hostile work environment against the village of Dolton and several of his former supervisors. The district court granted the defendant's motion for summary judgment because the record shows a material factual dispute on Taylor's discriminatory discharge claim. We affirm in part and vacate in part. So part of that summary judgment, the appellate court upheld, and part of it they vacated. So I just wanted to just kind of raise this up and bring this up because the allegations here, yeah, mighty similar to what David Duval claimed happened to him from Keith Freeman and Super Stupid, right? So Taylor claims, who was the black firefighter, that he was subjected to racially offensive language when he worked at the Dolton Fire Department between 2009 and 2013. Two lieutenants in particular, David Duval and Daniel Manning, used racial epithets and made derogatory comments to him about his race. Duval, for instance, repeatedly used the word N-word and disparaged Taylor's wife, who is white. Why? In addition, Taylor claims that on separate occasions, the two lieutenants and Fire Chief Terrence Hughes said that black firefighters don't belong in the fire station. The last racially offensive comment occurred in early 2012, but Taylor did not file an EEOC charge until February 2013. During his employment with the fire department, Taylor repeatedly was accused of smelling of alcohol while on duty, though no one saw him drinking on the job. Duval and another lieutenant, Mike Moreno, were the first to report him. Taylor denied drinking and highlighted Duval's history of racial harassment, suggesting that Duval made the accusation because of racial animus. Jerry McCullough, Hughes' predecessor as fire chief, investigated both the drinking allegations and Taylor's complaint of racial harassment, and in the process learned that coworkers previously had reported that Taylor smelled of alcohol. A similar drinking accusation was later made by another lieutenant, Daniel Manning. So I'm just gonna skim over this here. So basically, the accusations of Taylor using alcohol was then rose to the occasion where they asked him to do a blood test. He refused to do it, but agreed to take a breathalyzer test, which showed no trace of alcohol in his system. So by law, you don't, unless there's a court order, you don't have to agree to a blood test. The only time where it is not a choice is if they get a subpoena, which would be, they would have to go to court, get a judge to sign it based on probable cause, and have you ordered to do a blood test for alcohol testing. But otherwise, you can deny to do it. You can say, deny it. Say, no, I don't want to do it. I refuse it. But I mean, he did the breathalyzer test that showed no trace of alcohol. So McCullough regarded Taylor's refusal to take the blood test as insubordinate, and he placed Taylor on administrative leave pending further investigation. That's not insubordinate because McCullough cannot force Taylor to do a blood test for alcohol when the breathalyzer test did not show any trace of alcohol. So I mean, McCullough is not a sworn police officer. He's not. He didn't have an order. He can't. He didn't have probable cause. He can't force that. So that probably would have been part of the reason why the appellate court decided to vacate the summary default judgment, because he doesn't have standing to force him to do that. Around this time, Hughes replaced McCullough as fire chief, hoping to impose discipline short of firing Taylor. Hughes offered him a brief 3-day suspension. Taylor refused to accept this discipline. However, so Hughes fired him, citing insubordinate, threatening behavior. The following month, Tyler filed a complaint with EEOC. Thereafter, he filed the suit under Title VII of Civil Rights Act of 1964. 42 U.S.C. Statute 2000E. He alleged that he was subjected to a racially hostile work environment, fired because of his race. The district judge entered summary judgment for the defendants. Regarding the discriminatory discharge claim, the judge acknowledged Taylor's assertions that Hughes had made racist comments, but concluded that they were too remote in time from the termination decision to suggest discrimination. The judge held that the hostile work environment claim was untimely because the racial harassment occurred more than 300 days before Taylor filed his EEOC charge. When that happens, you get terminated, you go to EEOC the next day. How about that? Unless it's a Friday and you still got a weekend to deal with, then your behind needs to be at EEOC that Monday. Taylor moved for reconsideration, citing Ortiz v. Werner Enterprises, Inc. And this is 7th Circuit 2016 case, argued that the district court improperly compartmentalized and segmented the evidence rather than evaluating it as a whole. The judge denied the motion, concluding that Taylor's evidence of an atmosphere of racism in the department was insufficient to raise a material dispute about causation. So you need some evidence, right? You're saying that it created this atmosphere of it, but you can literally state if someone said something that was racially derogatory and the environment is immediately hostile, then you define that hostile work environment by law and cite that in your complaint. And then you give the evidence and the examples to support how that hostile work environment was created and upheld due to the racial discrimination and the derogatory statements that you endured or the harassment. It has to be concrete. You can't say that it is a suggestion or a hint of this if you're going to file an EEOC on it. So that's kind of how I'm reading this here. That's my understanding of this. So on appeal, Taylor maintains the district court's review of evidence obscured the link between racism at the fire department and his discharge. If the evidence were viewed holistically, he argues a reasonable fact finder could conclude that he was fired based on his race rather than insubordination, as the defendants contend. I don't know. I'm perplexed about that one because it sounds like, despite what he perceived that termination to be, he was definitely terminated because he refused to do a blood test. Now, he could have argued from the angle of this person not having the authority to force me to do a blood test, especially when I agreed to a breathalyzer, and that test result did not show any alcohol in my system. So why would I need to agree to go further to do a blood test? The preliminary test, which is the breathalyzer, showed nothing. I'm not required to give up my blood out of my body to someone who does not have the authority to order me to do so. And it's not coming from the department, it's just coming from an individual. That's like my manager calling me and saying, I need you to come down and do a urine sample to test for alcohol. Just just use the same example here. And I'm like, wait, what? And this is not coming from the HR department or anything like that. And it's not everybody being drug tested. It's a manager asking one individual employee to do it. And then when they don't do it, then you want to fire them on that. Well, then that could have been a wrongful discharge and wrongful termination. And retaliation of you're trying to violate my rights to access my property out of my body without just cause, with no court order, with no anything issued that gives you standing to mandate this. He could have brought that argument from that stance. That would have been much more, sound. He wasn't. I didn't seem like he was fired because of race, but he could have very well endured racial discrimination, though. But he could have literally used the reason he was terminated as enough justification to support at least a wrongful termination and retaliation. That would have been kind of my take on that, but that's my opinion on that. Yeah, my opinion. So they accordingly vacate the order granting the defendant summary judgment motion on the discriminatory discharge claim and remand for further proceedings. We affirm the order dismissing the hostile environment claim as untimely. So what ended up happening is, they vacated the order on the discrimination discharge. So they allowed him to go back. Okay, we can go ahead and have additional proceedings on that particular claim. And I would have taken that time, that opportunity, if I were him. This is an old case. All right. This is 2017. But if I were him, I would have taken the time. I don't know if Taylor's a him. It is a male. Okay. If I were him, I would have taken the time to say, I want to add in additional evidence. Since this is going to be heard in the appellate court, where I was discharged for insubordination from someone who didn't even have standing to take my property out my body. I agreed to do a breathalyzer test, even though I didn't have to agree to that. But there was no court order in place mandating me to do a blood test either. This didn't come from HR or anything. This came from a manager. So they still will need to follow, some chain of command and get an order to get me to do a blood test. Then they're accusing him of drinking on the job, but they didn't have any evidence to claim that to base a termination on that. They didn't even have any evidence to base an additional test on that. He agreed to the breathalyzer. It showed no results of alcohol in the system, no trace of alcohol. But then he got fired for not agreeing to do a blood test. It's ridiculous. So, that would have been sufficient enough for a wrongful termination here, and very direct and straightforward. But I do understand, if he's been called these words and referred to him as N-word, spook, moan, cricket, what the? Now, this is 2017. And this is including Manning and Duval. And I brought this up because just in the name of fairness, I think people need to see context and how other issues, very serious issues, have been handled and addressed in the past. When I saw this, I was trying to find the collective bargaining agreement that was signed last year between Jason House and Adam Farage. And this case came up and I read over it and I said, wow, I would not have expected this. I got to be honest, especially considering what David Duval went through. If we read it just from that perspective, we're getting one side of it. But seeing this case and seeing a whole nother side of this David Duval person, it does not invalidate the lawsuit. It doesn't. That had nothing to do with race or anything. It's about theft of wages and retaliation, to which he should not have endured. But I would implore David Duval to consider, if these things be true, what he went through. And what he may have perpetuated on someone else. So this is just to show you all that it is okay to hold people accountable, even when they have been wrong themselves. But if they do something wrong, don't sit here and get scared. This is how you end up with someone being in some position for 4 years and you can't get rid of them because you didn't say anything to begin with. And when you don't say anything, it almost invalidates that person's behavior and it gives off this impression that they're justified to behave and act the way they do. They're justified to make these decisions that make no sense. So, do you have to sit here and rah rah? No, you don't. I'm very calm. I'm real chill right now. If you all knew, very chill. But it doesn't mean that right isn't right and wrong isn't wrong. Right is right and wrong is wrong. Facts are facts. Laws are laws, and they're not debatable. Your opinion is. But if you decide to say, okay, we have these people in charge now, we can all get back to normal and get back to ignoring what's happening. That's when you've already kind of given up, the power you have and the ball in your court, so to speak. And now you put yourself in a situation to where you're probably going to end up having the same result. I'm not saying I don't think anybody in this administration is as horrible as super stupid and her goons. I just, they're not under FBI investigation. Let's start with that. Have they done things that they should not have done? Yes. One of those decisions I went off about in at least 2 videos. Does it mean that you should not speak out? No, you should speak out. And you should speak out when it happens. Don't let this stuff pile up and then you find out 2 years from now this is how y'all really felt. And everybody's like, well, we didn't know y'all felt this way. Because you're trying to sit here and now we're just not going to say anything now. What is going on? What do you mean? You're grown adults. You can be tactful in how you speak out. But I cannot fathom anyone just wholeheartedly trying to protect someone, even when there's sufficient evidence of wrongdoing in court documents, in administrative hearing recommendations and orders, as if laws and rules somehow don't apply to them. And you have dumb goons that somehow want to try to bend and manipulate what we know as laws and rules and try to give some exception. No, we don't do that, which is why it's even more important to ensure that Jason House and this administration is still held accountable and that you still voice your concerns when there is a decision that is made that we can all collectively agree it is a bad decision. He who will not be named being put on a committee, we all collectively agreed was a horrible decision. Horrible decision. And it was corrected. That is because people voiced their concerns. Whether I live there or not is irrelevant because right is right and wrong is wrong. So I hope you guys enjoyed this video. This is pretty lengthy, but it's worth it. I thank you all for your time and attention. Put this video on 1.5 speed. We went over a lot of information here, but it was information that I wanted to get to and I wanted to touch on just so, more context can be provided as to why I still call super stupid what she is. And why, Keith Freeman still sucks and why, Delgado Law Group is the worst law group ever. And at the end of the day, while it is important to still hold our leaders accountable, no matter who they are, they wanted this. Jason House, all the trustees that were newly elected said, hold us responsible, hold our feet to the fire. Okay, wish granted. Don't get mad when we do. Where's my 4-year request? I need the village clerk to send me my stuff. Yeah, come on, send me my 4-year request now. Don't make me have to send it twice. I mean, I'm getting annoyed. But see that? Holding them to the fire, and you're not going rah-rah and getting all angry on it. It's not necessary. You can catch more flies with honey than you can with vinegar. But when it comes down to me going to mama mode and fussing, I'm still going to do it. All right. Thank you all for tuning in. Hit the like button and subscribe. And if you're enjoying the content that we're putting out here in the Lady Luck Club, consider becoming a member because there's more to come with that. I'm still waiting on the FBI to finalize my request for the foyer for that FBI subpoena. Oh, that's going to be liquid gold when I get it. That is going to be made available to the members and then probably available to the public. Thank you all so much for your support. Thank you all for um, any support you want to provide to the channel. Ways to donate is Cash App, Lady Luck Club LLC. And if you want to donate through Zelle, it is Lady Luck Club LLC at yahoo.com, which is my email for the channel. You guys feel free, as always, to leave comments. Let me know your thoughts. Thank you all for the supers. Thank you all for the encouraging words. I appreciate that too. And for the responses, the video with Keith McNugget is doing well. Let's make sure we keep up the pace with the He Who Will Not Be Named video that I premiered last night. I had finished recording it and just did an instant premiere. And you know, I just wanted to get that information out there for you all as well as this. So thank you so much. You guys have a good evening, and to the next one, Lady Look Out. Deuces.